very
sure,
quick.
go ahead.
I know you're busy, Rep, and I'm sorry. And it's not, you mentioned about, the redaction of information, and, we often hear that, and the seal and destruction of records. I mean, there's a thing called a computer. It's a dastardly thing, you know what I mean? And if you ever think that stuff goes away, and I'm sure we could, I'll defer to the police and, former attorney generals that are in this room. It just never goes away. I mean, I had a gentleman that I thought we, sealed and destroyed his record, and he went for a job yesterday, and lo and behold, guess what my headache was all day? And good thing he hand-delivered it to the Attorney General's office. And you know something, he went there today about 3:30, and, he's a gentleman of color, and they said, oh, we made a mistake. It may cost him a job now. Now, how does he, as Secretary Donovan said, how do I get my name back? How do I get my reputation back? So this stuff really never goes away, and I would imagine that, if sometimes police do it just to get a beat on somebody. They know that John Lombardi's driving around with a $200,000 car, and, he works, he doesn't work. Why is that happening? That stuff never happens, does it, Mr.
Never.
Chairman? So it just, anyway, it's very interesting. Again, I would ask the same question as I did earlier, not of you, of minds greater than mine, certainly, all the lawyers, which is certainly, I'm not one, I make believe I'm one.
And to answer your question, your specific thing, I think that's a qualified immunity issue. Does your client, unfortunately, based on that, I don't think your client even has any kind of civil repercussion, because they're probably covered under some variation of,
Well, I wasn't worried about my client, I'm more about this here. What I'm saying is about the dissemination of information. Look, it's out there.
Yeah.
It is out there. I mean, these things.
And the best we can do,
Yeah.
and the best we can do is dictate that it is destroyed, and then, then it's upon us to, if we feel that it's a problem, it's not being destroyed, it's upon us to develop legislation and some variation of an auditing process, possibly, to make sure that it is, if it's a big enough problem.
I'm sure this stuff has been litigated. I'm going to go harken back to what Representative Corvese said earlier. I'm just, again, is it will it pass constitutional muster? That's my only, again, not for you, but that's the question that's in my mind right now. I just don't know.
I think, just based on my observation, again, as a layman in the room, I think Representative Batista referred to it. The Supreme Court doesn't gig you, for lack of a better term, or declare something unconstitutional if you're increasing the restrictions on the government. They only do that when you're increasing restrictions on the individuals, on the citizens. So if you increase the restrictions and you put the government under a broader microscope and put them into a higher standard, I don't think the Supreme Court's necessarily going to come back and say that you're doing something unconstitutional, because the Constitution is designed to restrict the government, not the citizens. And if we're further restricting the government, I don't see them having an issue with it, especially based on the composition of the current Supreme Court, and both Democrat and Republican nominees are current justices. You've got a very friendly civil libertarian judiciary right now. So
I don't know if I necessarily agree with that, but again, I'm just, constitutional muster is my only issue, Mr. Chairman. I'm not taking issue with the bill one way or the other.
Vice Chair Knight.
I just want to point out, from the historical point of view, this body created the administrative subpoena within the last 10 years. It is used every day by law enforcement out there to query Cox or Verizon or whoever about subscriber data and whatnot. It's a key part of their investigative tools. I'm of two minds about it, because on the one hand, it's okay under current Fourth Amendment logic, because you're presumably, when you operate your phone and it emits signals that are open for other people to see, then those signals, you don't have an expectation of privacy in that information. On the other hand, technology is getting to the point where a person who was really interested enough could piece together all kinds of stuff about me not otherwise available from signals that my phone emanates to other folks. So there's somewhere in there is the line at which we have to tell law enforcement, look, you got to go get a warrant. I appreciate that it might be a bit of a headache, but, you know, really, it's not. Draft it up, go to the judge.
And I think the spirit of the original Bill of Rights is the idea is the government can't come in and look over your shoulder and see exactly what it is that you're writing and putting onto paper and the conversations that you're having. And I think this meets the spirit of what that original Bill of Rights was intended to do, that the government can't in some way, shape, or form, regardless of whether it's being emitted by a it's being just thrown out there, they can't come in and just look over your shoulder and see the keystrokes that you made into your cell phone or the pictures that you took or the places that you walked by, just because the Supreme Court can't, find it amongst themselves to recognize that technology has changed.
And sooner or later, I would expect a savvy mobile operator, probably T-Mobile, to just decide to encrypt the location signals, and then it'll just lock out law enforcement altogether, which will be a whole other conversation, because then I think Congress would go ape about that.
I think that's what you see with the iPhone. I mean, you see that today. There's so many people are so concerned about the government getting a hold of it. The iPhone encryption is just unbelievable, and Apple's put their foot in the sand.
Yeah.
They put their heels in the ground and saying, we're not going to give this up because that's a key metric. And even if they had the proper warrant to look at the phone, because Apple has taken it upon themselves to make it so encrypted, they can't get access to it. They can't get access to it.
Yeah.
They can't break into the phone.
It's a conundrum, because somewhere in there is the appropriate balance between rights and the ability of society to ferret out crime. I don't know where the right point in the middle is, but it's somewhere there.
It's decided in this room in judiciary in the state of Rhode Island. But that's what the Supreme Court has said. The Supreme Court has said, under issues like this, it should be decided by the states because technology has advanced so fast since so many different opinions have been given. I mean, I think the third-party doctrine was originally incorporated back in the 1970s. I believe so again, we're talking decades before even the cell phones, and what they've done is they've taken prior case law and evolved it to meet the current technological abilities of the stuff we have. And again, the question is, do we agree with their interpretation or don't we? And that's why the bill's here, so we can have these conversations.
Great. Any other questions of the sponsor? Okay, we'll get back to the two witnesses, and we'll go to the next bill we can put in play on behalf of Representative Norrie.